Welcome back to Organize, the business law breakdown. I'm your host, Seth C. Oranburg, and today we're diving into a cornerstone of contract law, the Statute of Frauds, which is a bit of a funny name for basically the concept you need to sign stuff in order for it to be enforceable. The Statute of Frauds was one time ago a statute intended to prevent fraud. But today, it's understood as the variety of reasons we need contracts to be in writing. A preliminary question is, why? Why does the law insist on signatures for some deals and not others? That's what we're going to unpack today. Let's imagine this. You make a verbal agreement to buy a car, but when it's time to hand over the keys, the seller backs out. Can you enforce the promise? Does the law require more than a mere handshake? Today, we're breaking down when the law demands written proof and why. In previous episodes, we've discussed how promises and exchanges can form legally binding contracts, but not all contracts can be enforced based on verbal agreements alone. The Statute of Frauds steps in to protect certain transactions by requiring that they be in writing. Today, we'll cover all the types of contracts that must be in writing under the Statute of Frauds under the common law. Things like contracts for sales of good over a certain amount, contracts that take more than a year to complete, and agreements involving real estate. I will note that each state has its own versions of statute of frauds, and there can be federal requirements as well. So we'll be dealing with the common law categories, and obviously you should consult an attorney for advice on your local jurisdiction. We'll also dive into key cases like Crabtree versus Elizabeth Arden Sales Corp., which highlight the practical application of the statute of frauds and its exceptions. Before we dive into details, let's identify three key takeaways you'll learn from listening to today's episode. You'll learn about the statute of frauds, which requires certain types of contracts to be in writing to be enforceable, including contracts for sales of land and agreements that cannot be performed within a year. We'll explore the key exceptions to the statute of frauds, such as partial performance and promissory estoppel, which can allow courts to enforce oral agreements in certain circumstances. And we'll discuss the consequences of failing to meet the statute of frauds requirements, including how courts handle disputes when no written contract exists. So, if you've ever wondered when a handshake isn't enough to seal the deal, stick around. We're about to break down why sometimes it's all about the John Hancock. Now that we've set the stage, let's dive into the basics of the statute of frauds. The statute of frauds is a legal doctrine that dates back to 17th century England, and it's still relevant today. At its core, it requires certain types of contracts to be in writing to be enforceable. Why? Well, the main goal was to prevent fraud by requiring that contracts be in writing so there was some proof. But there are some additional reasons why we might want deals in writing. For example, we channel our agreements into certain types of forms, which makes it easier and more efficient to process those. Anyway, for all of the reasons that we have for contracts to be in writing, only some of them need to be. And under common law, there are 5 categories plus a reference to a 6th one under the Uniform Commercial Code. And we can remember them using an acronym, MILEGS, MYLEGS. MILEGS is just a funny way of remembering the categories that contracts typically require writings under the common law statute of frauds. So let's run through MILEGS real quickly. M is for marriage, Y is for year, L is for land, E is for executorship, G is for goods worth $500 or more, and S is for surety. We're going to dive into what each of these means, but truly only a few of them are really important quite often. Contracts for sale of goods, obviously that comes up all the time because a lot of stuff costs more than $500. Contracts for real estate definitely need to be in writing. We've got that one very clear. And contracts that cannot be performed within 1 year is a little tricky to understand sometimes. The marriage provision comes up less often. There's not a lot of contracts one makes in consideration of marriage. This is a throwback to ideas like dowry. You may not be functioning as an executor or providing suretyship, although if you've ever co-signed a lease Someone was acting as a surety. The cosigner is acting as a assurance that the debt will be paid. And so these are examples of the general categories where you need to have a writing, some, of course, being more important and relevant than others. These categories exist again because generally when we have complex or significant stakes, we want to have a requirement of a writing to avoid disputes that can arise because people lie, because people forget, because it can be difficult to understand what a contract means when we had simply not written it down in plain English or in legal English, either way. For a contract to satisfy the statute of frauds, it doesn't have to be elaborate. In fact, we don't actually need the contract itself in writing. We need this contract to be evidenced by a signed document, but it doesn't have to itself be signed. We need a signed writing that represents the formation of the contract. And again, this is nothing necessarily elaborate or complex. This could be a simple email to the extent that emails count as signed. It could be a receipt which has letterhead printed on it if done in an appropriate way. Typically what you'll find is pen and ink signature on a piece of paper, but of course we can have electronic signatures as well thanks to the e-sign act. Of course, like many rules in contract law, there are exceptions to the statute of frauds, and one major exception is the doctrine of partial performance. If one party has already begun to fulfill their part of the agreement, courts may enforce the contract even if it wasn't in writing, just because it would be unfair to let one party benefit from the other's actions without holding them to the deal. One classic case that illustrates this, what we'll talk about later, is Crabtree versus Elizabeth Arden Sales Corporation. In this case, a person named Crabtree was hired on a verbal promise for a 2-year employment contract. Obviously, you can't perform 2 years of employment in less than 1 year, so it fell within the year provision. Remembering MyLegs, M-Y-L-E-G-S, that's the Y in MyLegs for year. Later, the company tried to renege on the deal, arguing it wasn't enforceable under the statute of frauds. However, the court found that if you compiled various documents taken together, some memos, some notes, some receipts for paying the guy, that satisfied the writing requirement. Again, this case shows that you don't actually have to sign the contract itself to satisfy the statute of frauds. What you need is some type of writing which shows there was a contract, and that writing needs to be signed. So to summarize, the statute of frauds is to safeguard and ensure that important contracts are documented in writing, or at least memorialized by some type of evidence that is written down, because people forget, people lie, things happen. While this rule applies to several key types of agreements, as you can remember through the MyLegs acronym, marriage, year, land, executorship, goods over $500, and surety, the law also recognizes that certain exceptions may justify a contract not being written down. Okay, that's the basics. Let's break it down with a closer look at how the statute of frauds plays out in real-life cases, starting with the aforementioned Crabtree versus Elizabeth Arden Sales Corporation. This case shows how even when a contract isn't fully in writing, the court can sometimes enforce it, even if the key terms are reflected in multiple documents. Again, the court is not trying to mess around with formalistic requirements. We're in a legal realist era. And so the question is there sufficient evidence that this contract existed? So here's the facts. In Crabtree, the plaintiff, a person named Crabtree, was hired by Elizabeth Arden Sales Corporation with the understanding he would receive salary increases over a 2-year period. However, this agreement was made verbally. And when the company refused to honor the promised raises, they argued the statute of frauds required that contract be in writing because it would play out over a term longer than 1 year. 2 years employment can't be accomplished in 1 year, triggers the year provision in our MyLegs mnemonic. That's the Y. The key issue was whether the statute of frauds rendered the contract unenforceable due to the lack of a single written document. But the court found that several documents, when taken together, could satisfy the writing requirement. There were memos and notes reflecting the agreed upon salary increases, and these various writings combined were enough to create an enforceable contract. The takeaway from Crabtree versus Elizabeth Arden is that courts will sometimes piece together multiple documents to satisfy the statute of frauds writing requirement. Even if there's no formal signed contract, the statute can be met if key terms are laid across different writings and they reflect the agreement. It's a reminder that the writing requirement is flexible and we are not looking for a signed contract. That's the biggest error students and many people make. We don't need the contract to be signed. We need a memorandum evidencing the contract to be signed. What matters is that the core elements are documented such that we know the contract really existed and people aren't lying. So we've broken down how courts apply the statute of frauds in practice. Let's talk about a what-if scenario. Let's say you've made a verbal agreement to buy a car from your neighbor for $1,500. When the day comes to exchange the money for the car, your neighbor changes their mind and refuses to sell. Can you enforce the verbal agreement, or does the statute of frauds require you have something more to evidence this deal? Well, let's look at my legs. Is this contract in consideration of marriage? Nope. Does this have to be performed in more than 1 year? No, this is going to happen like tomorrow. Is this about land? Nope, cars are not land. Is there an executor here? No dead people, no executor of an estate. How about goods for more than $500? Ding, ding, ding. Okay, this one is where we hit on because we have a car that is something that is movable and identifiable at the time of sale. The price, $1,500. $1,500 is more than $500. That means it falls under the statute of frauds. And by the way, the S in suretyship doesn't apply here either. Since this contract falls within the statute of frauds and it was verbal and there's no writing to prove the contract, it's likely unenforceable. The law requires that contracts for the sale of goods over $500 be in writing. So without that, your neighbor isn't bound to the deal. Now, what if you had exchanged emails about this instead of having a mere verbal agreement? What if you had an email even saying from your neighbor, I look forward to see you tomorrow to exchange the money for the car. I can't wait to get rid of this thing. Well, that might be enough. An email could constitute being signed. We have to look at that in some more detail as to whether it's signed or not. But if it comes from an authenticated email address, it could provide evidence. And of course, an email is in writing. Let's take another what-if scenario. So what if instead of refusing to sell, your neighbor has already handed over the car and you're driving it around town, but you haven't paid yet? So while you're driving the car around, you decide, well, even though $1,500 is pretty cheap, I really don't like this car. It makes this clunky noise and I'm worried about it. And you take it back. You take it back and you drop it off and you say to the neighbor, I told you I'd pay tomorrow, but I'm not going to do that. Now it's your turn to say the statute of frauds prevents enforcement of the agreement. This time we might have an exception. This scenario introduces the doctrine of partial performance. Because you've already taken possession of the car and your neighbor delivered it, your neighbor's performed his side of the obligation. Courts might decide to enforce this agreement. The fact that you picked up the car, drove it around town, maybe registered it in your name or something like that, treated it like it was yours, that might be enough to override the statute of frauds because now we have some partial performance where one party has fully performed their part of the deal and it's just waiting on you. It sure seems like there was a deal. Otherwise, why are you driving the car around town if you didn't buy it from your neighbor? There might be other reasons, of course, but here we have some other evidence, the fact that you were driving the car around to show there was a transaction. Again, the purpose here is to avoid fraud. If your neighbor lent you the car, and it was a real clunker of a car, and then later claimed that you owed him $1,500 to purchase it, then the statute of frauds kicks in to prevent that kind of fraudulent behavior where the neighbor effectively uses the court system to take advantage of the contract you don't have. So let's have one last what if. Suppose you and a friend agreed that they'll work for you for 3 years in exchange for a percentage of your profits. A year into the agreement, they decide to quit and ask for their payout. Can they enforce the verbal contract, or does the statute of frauds come into play? Here, the agreement was longer than a year. So going back to my legs, we hit the Y in my legs, and so it falls under the statute of frauds, which requires contracts to be in writing. And without a written agreement, your friend won't be able to enforce the contract unless there is some kind of exception. For example, if there was some type of detrimental reliance and a promissory estoppel kind of argument, it was possible that courts would take pity on the situation and on your friend. But the statute of frauds is designed to prevent this sort of thing from happening. And if you want to have a deal that you look back on 2 years later, you need to put it in writing. And the statute of frauds is clear that contracts that can't be performed within a year must be in writing to be valid. So, as we've seen, the statute of frauds steps in when certain contracts, like those for goods over $500 or agreements lasting more than a year, aren't in writing. However, exceptions like partial performance can save the day, allowing courts to enforce the deal, even if it wasn't written down. Let's take a look at how the concept of needing a signed contract plays out in pop culture. One of the best examples in a TV show or movie is where handshake deals go hilariously wrong, like in The Office. Michael Scott verbally promises an employee a raise, but when it comes time to deliver the promise, the lack of a formal agreement creates chaos. It's a common illustration of the statute of frauds in action. When certain agreements require a written contract, things can get messy when you don't have one. There's a good reason we require contracts to be written in these cases. While, again, a contract does not have to be written in all cases, in serious ones, we want to have it in writing to avoid people misremembering, to put it courteously, what deal was struck. Another pop culture moment comes from Jerry Maguire. In the movie, Jerry and his client, Rod Tidwell, verbally agree to work together. It does work out, but what if things had gone south? What if Rod decided to ditch Jerry and sign with another agent? Without a signed contract, Jerry might have found it difficult to enforce their verbal agreement, especially since the stakes involved millions of dollars and extended over multiple years. Now, in this particular case, it's possible that Jerry found Rod his placement within 1 year. So, as a technical matter, the statute of frauds Y provision, the year provision, may not have been triggered. Different jurisdictions actually take this differently, whether it's possible or plausible to have something performed within a year. But again, things get messy. And so the general advice is, if you have the opportunity to put it in writing, you ought to do so. Time and time again, we see that handshake deals and verbal promises lead to legal gray areas. The statute of frauds exists to protect against those situations and to ensure that certain agreements are clear, documented, and enforceable. So if you're a lawyer and your client asks you, do I need to get this in writing? My default answer would probably be, you should. Even if you don't need it under the statute of frauds, as the most technical of matters, getting contracts in writing can avoid all kinds of problems and proof problems down the road. Let's recap what we've covered today. We started by discussing the statute of frauds, a legal safeguard that requires certain kinds of documents, like those for sales of goods over $500 or agreements lasting more than a year, to be in writing. This rule ensures that important agreements are documented and enforceable, reducing the chance of misunderstandings or fraud. In the Break It Down segment, we explored cases like Crabtree versus Elizabeth Arden. This case showed that even informal writings like letters or memos can sometimes satisfy the statute of frauds if they clearly outline the key terms of the agreement. We also saw that partial performance can sometimes override the writing requirement as courts aim to prevent unfair outcomes. We certainly don't want the statute of frauds to create fraud in the courts. The key takeaway is that while the statute of frauds exists to require written proof for certain contracts, courts are flexible in how they apply the rule, because underlying the rule is the intention of preventing fraud and not allowing the courts to be vehicles to conduct it. As long as the main terms of the contract are documented and one party has begun to act on the agreement, the contract is likely to be enforceable even without a formal signed contract. Have you ever made an important agreement based on a handshake or a verbal promise? How did it turn out? Were you ever nervous that it wouldn't be honored? I'd love to hear your experiences or any questions you have about contracts and the statute of frauds. Share them with me, and you might hear your story in a future episode. Don't forget to subscribe, leave a review, and share this podcast with anyone who's interested in learning more about the complexities of business and contract law. In our next episode, we'll explore the doctrine of mistake. What happens when both parties in a contract make an error about a fundamental fact, and how does the law handle those mistakes? That's all for today's episode of Organized, the Business Law Breakdown. I'm Seth C. Oranburg, and I thank you for contemplating the statute of frauds with me today. I hope you found the episode enlightening and practical. Remember, until next time, keep your agreement strong and your arguments stronger.